Good morning friends, Namaskar, Sat Sri Akal and Adab. This is my 209th video covering Ambala cantonment and those resumption notices issued to another property, bungalow number 68, survey number 318, area 2.74 acres, originally owned by Anjuman Himyat Islam, who had migrated to Lahore, and it became an Evacuee property after 1947. So the custodian is Punjab Wakf Board. The resumption notice issued wide 71068 of 1794, 16th March 1971. Like all other owners, Punjab Wakf Board filed a suit in the lower court as a suit for declaration against this resumption notice, and finally gets a similar order which it got for 68A on 29/4/1978. Here the compensation amount of the built up area is 4524. Now friends, these two videos, if you merge, one is 1.71 acres and the other is approximately 2.74. I have a document which says that this 68 and 68 was one property. This was one grant in 1880. I have the sale deed. When was it bifurcated? When was the grant divided? Now most of us hear that grant is non-divisible, but here it is divisible, and this is a case in Ambala where a grant has been divided. Similarly, this case is fought on the same grounds what was fought on 68A. Notice is illegal, void, bungalow falls within House Accommodation Act area, and Punjab Wakf Board Evacuee properties cannot be issued resumption notices. It is ineffective to them after the Evacuee Act. So various things, written statements, again it is a rent-free property under the GGO, building belongs, and so many things. Issues are very similar. You know, sometimes I feel these three cases, 68, 68A and 71, are copy-paste. Resumption notices don't have the same date, but the pleadings and the replies and the order by Honorable A.S.Garg is the copy-paste. Same date, same Honorable Court, and the order comes. Issues absolutely similar. No, simple issue, whether the order of resumption is illegal, whether the court has jurisdiction. So such a simple issue, no ownership, nothing whether House Accommodation Act, nothing whether notice can be issued, whether the land falls within GGO, nothing. The plaintiff is claiming to be an owner, but the issue of ownership is not coming up. Why, I don't know, because maybe because of being an Evacuee property. So this issue does not come up by the Honorable Court. Neither does the plaintiff press for it, neither does the defendant press for this. So whether they are the owners of the land under the GGO, they don't press for it either. So various documents are produced, the same question, the position therefore which can be ascertained from the facts on the record is that there is no evidence that the property was dedicated to Wakf. By a mere statement of Secretary of Wakf Board, the property cannot be proved to be a Wakf property. There has to be a definite evidence to show that the property was actually dedicated to the Wakf. Wakf Board did not produce any record that the property was duly entered as property of the Wakf in their relevant registers. There is no copy of survey that the property should be deemed to be dedicated to the Wakf property. So now you understand this is not a Wakf property. It is a property which was put under the Evacuee, but the Wakf Board or the Evacuee rent officer did not auction this property under the Evacuee Act of 1952. So automatically this property was taken over by the Punjab Wakf Board, but they did not convert it into a Wakf property. We have bungalow number 50 in Ambala, which is the Punjab Wakf Board office. That is a Wakf property. Now this is not a Wakf property, they converted into an employee's residence of the Wakf Board. So nothing comes on record. Now only the question remain is as to whether the property could directly be resumed by Union of India. A notice should have been given as to whether the compensation was offered to the plaintiff is adequate. Various judgments have come to the conclusion regarding the property can be resumed. This is the court saying in its order. Therefore, obviously the resumption proceedings which without notice and without adequate compensation are bad in law as well as against the justice and the good conscience of the law. The learned counsel of the defendant could not support his case, could not explain by way of cogent arguments as to why the notice was not affordable to the plaintiffs in the resumption. Even now there is nothing on record to contradict the estimates prepared by the Punjab Wakf Board. Punjab Wakf Board had tendered an estimate of the property varying to about some 30,000-40,000 rupees. Exhibit P3 is the noting on behalf of the defendant that the compensation was quite adequate. Therefore, there is no ground to say all this. So, therefore, this resumption notice is illegal without jurisdiction. So, for the want of the compensation of natural justice, I debar this resumption notice and the notice is quashed. Same judgment, 29/4/1978. Similar happening. Why didn't the department go in appeal? Read the chapter 23 of volume 2, Cantonment Act 2006, JP Mittal, page 700. So there is a big lapse. This needs to be known. Under the RTI, the department in 2010 and 13 admitted that yes, bungalow number 68 was given a resumption notice. Appeals were not filed. De novo proceedings are going on. Again, like 68A, 68 is again issued a construction notice under 185. The notice reply is filed, an appeal is filed to the Western Command, and later in 79 a judgment comes, similar grounds like it came in 68A. Same law or judgment, same judgments were quoted. So no encroachment was done, could be compounded or penalized. So this is how cases are fought. I don't know whether it was the department who was not willing to take bungalow number 68 or was it the Punjab Wakf Board in a more stronger. Because when you read these two cases, I feel the department could have fought this case. But why it didn't do it? It's a reason known to the officers posted then. Later from 2010 till 13 and 24, nothing the department has done against these bungalows which I just mentioned. So this is clear-cut discrimination. We need to understand. Thank you. Good day.